So welcome to today's HR Matters webinar, which we're hosting on behalf of Greater Manchester Chamber of Commerce. The session is live today, but you've all joined on mute. However, we do like a bit of participation. So if you have any questions on today's topic as you're listening to us, then please use the Q&A function to raise those questions. And we will either attempt to answer them at the end if we have got time, or alternatively, if you leave your name, we'll be able to follow up with you after the session instead. If you do have any technical issues today, the chat function is the best one for that. The lovely Tom Williams from our business development team is on hand to support with any technical issues. So please use the chat function to speak to Tom and he'll be able to assist. By way of introduction, my name is Laura Tracy. I am a partner in the employment team here at Freeths. I'm joined by Matt Fraser today, who is a legal director from our employment team, and also Dan McNally, who's a director from our compliance and regulatory team. For the regulars to HR Matters, Dan will be a new face for you, I think. So he's our star of the show today. Dan, no pressure. Dan advises businesses who are the subject of criminal and regulatory investigations, including those carried out by the Health and Safety Executive. He also represents companies who are facing allegations of corporate manslaughter and breaches of health and safety. So it's great to have him joining the session today. So thank you, Dan.
Thank you.
The topic of today's session, as you all know, is mental health and wellbeing at work, specifically looking at the legal responsibilities for employers. How big an issue is this? Well, Mental Health First Aid England report that a quarter, so 25% of UK workers report feeling unable to cope with workplace stress. It definitely shows the need for more support in this area. 2 years ago, 51% of employees showed symptoms of burnout, like exhaustion, sort of disengagement with their work. Last year, it was 63%. So 51% to 63%. This is absolutely an issue on the rise. I'm sure you're seeing this in your organisations. And as an employment team, we're absolutely seeing this play out in the queries that we're receiving from clients. So hopefully this is a timely session for everybody. We'll just have a look at the contents slide, please. Thank you. So today what we'll be covering, the first thing, the why. So there's a clear moral argument, obviously, for protecting the mental health and well-being of work colleagues, but we're also going to look at the business case for doing so. We're going to look at how to identify the main risk factors for stress in the workplace and how those factors might show up day to day. We're then going to look at the legal obligations, so to protect workers from stress, and Dan is going to guide us on some of those health and safety duties. Matt's going to help us then with the crossover with the duty to make reasonable adjustments for disability. We're going to look at what happens if it goes wrong. So what are the penalties for non-compliance? And finally, we'll end with the practical steps to take to meet your obligations. Okay, without further ado, we'll move on. Excuse me. So what is the impact on business? Well, according to reports, work-related mental health issues cost the UK economy £57.4 billion each year. Now, when I hear a statistic like that, I have absolutely no idea what that means to my clients, to my businesses. What is £57.4 billion? Well, perhaps to put it in a framework that means something more to you, 10% of UK adults take time off or took time off for mental health reasons in the last year. 10%, that's really significant. And of those, almost half of those, the absence was a month or longer. And we all know what that means for our businesses in terms of the impact of absences. And move on to the next slide, please. So what do we see as the impact on businesses? Well, and as I say, we obviously know, as I mentioned, that there is a good, strong moral argument for looking after our employees. We're thinking here about, I suppose, some of the side effects of that, the financial cost reasons. Some organisations need to see impact on bottom line to really put their thought and care behind some of these issues. So we thought it'd be useful to think about this topic in that framework. So productivity, first of all, we often think of mental health as being an absence problem, because when employees go off sick for work-related stress or anxiety or mental health reasons, that can often be the first indication that there is an issue. However, it is unusual, as you know, for mental health issues to simply arrive kind of unannounced one day. And often it can be a build-up over time, which might then be exacerbated by sort of a triggering event, either in somebody's personal life or indeed at work. So one of the ways in which poor mental health can first show up at work is in reduced productivity. Poor mental health can lead to lower performance, and particularly an inability to deal with sort of higher stress periods. That clearly has a direct cost impact on business, because in sort of hard terms, your salary and your overhead costs, etc., are all the same, but the output that you're receiving from your employees is significantly less. When an employee then becomes unable to sustain that attendance at work because of mental health issues, this then becomes an absence cost. As I mentioned, 10% of UK adults took time off for mental health reasons in the past year. And regardless of whether you pay full pay during sickness absence or statutory sick pay only, absenteeism absolutely has a direct cost impact. Depending on the role, you may need to pay overtime to provide cover. You might need to engage agency workers. And where that employee is perhaps a manager or a more senior person, their absence can also affect customer and client relationships, or even the sort of stability of the team that they manage, which again has business and commercial impacts. Obviously, employees may take a period of leave, or they may instead choose to leave the business, indeed, to find a kind of a less demanding role, or an employer where more support is available for their well-being. So we've obviously mentioned turnover and recruitment costs there. High staff turnover also disrupts team dynamics, we know, and increases recruitment and training costs. Poor mental health and well-being can also lead to an increase in grievances and disputes within the organisation. In turn, these again sort of affect the productivity of those involved, obviously a huge distraction to the business when there is ongoing grievances and disputes taking place. We often see that it also has a bit of a knock-on effect. So where a relationship breaks down and one party ends up going off sick, a grievance is then raised against another person. And grievances obviously take a huge amount of management time and resources to resolve too. Legal costs and reputational damage we'll go on to look at. Obviously, legal claims carry the risk of reputational damage because the hearings and the judgments are publicly available. But we also see employees turning to social media and sites like Glassdoor from time to time to report their experiences on the level of support they've received from their organisations, which again can damage company reputation and again make recruitment much harder. I suppose in summary, the time and the costs spent on dealing with the impact of poor support for mental health and not, are not on your kind of core business has a direct impact on your bottom line. As mentioned, a sort of a good and a responsible employer will obviously want to protect its employees, but it is worth remembering that it will also have a direct impact on profit for those that need to see something in financial terms in order to prioritise it. So let's look at the main causes of stress in the workplace now. Next slide, please. And again. Super. So the HSE has published management standards that cover 6 areas of work that, if not properly managed, are associated with poor health, lower productivity, and increased accident and sickness absence rates. So demands being the first one. So this includes workload, work environment, and working patterns. Control, so how much the individual can influence how they do their work. Support, so this includes areas like mentorship, the resources they have available, and smaller things like, I suppose, the encouragement and appreciation that might be offered to that employee by their managers. the overall organisational culture. It can also cover how an individual is supported when life pressures like family illness or bereavement or family problems are causing pressure and stress. A report from Mental Health First Aid England last year says that financial pressure is the top external pressure faced by employees, affecting 41% of employees, and an increase from 37% each year. So remember, as we're talking today, we're not just talking about mental health issues which are caused by work stress necessarily, and we also have to think about those external pressures which influence how people turn up for work. Relationships. So this includes the way that managers and team members relate to each other, how the sort of positive relationships are fostered, how conflict is managed, and the impact that that has on the kind of culture and day-to-day working experience of the individual. Role expectations. So how much clarity does an employee have over their role and the expectations of them within that role? And finally, change. So this covers how organizational change is communicated and managed within the organization. So those are the sorts of main causes, as I say, of stress in the workplace as identified by the HSE. And we'll be looking later at the session at some of the practical steps we can take to address some of those stresses. Go on to the next slide, please. So how do you identify the main risk factors in your workplace? Well, your organization might already collect information that you can use to identify any work-related stresses, but it's a good idea to use more than one data source and then kind of look for correlations amongst them all. An obvious one is sickness absence data, but it's important to remember that stress might not always be recorded as the reason for sickness absence, and stress can show up in lots of different ways. So it might be migraines, it might be upset stomachs, it might be aches and pains, it could be inflammation. You know, those may be sort of symptoms of feeling increased stress. It's also important to look for patterns such as frequent short-term absence or long-term leave, especially following sort of busy periods of work, high stress periods or organizational changes, because that could indicate that the absence is related to those stresses at work. Productivity statistics. So lower than expected performance might indicate a problem. So look for things like missed targets, which don't have another reasonable explanation, or just lower than expected quality of work from your employees. That might indicate that there is an issue there. High staff turnover, obviously. And it's important to remember the benefit of those exit interviews. So consider any of the reasons raised in exit interviews as to why people are leaving. That it might be that they don't necessarily say it's because of stress at work, but indications about breakdowns in relationships with managers and demands and control, those sorts of things may arise as part of those exit discussions. Complaints. So thinking here about sort of any increase in disciplinary issues or formal complaints, they could indicate poor management or unresolved kind of interpersonal conflicts within specific teams. And of course, feedback from staff. You know, speaking to staff is incredibly important to be able to identify any of these risk factors. How that might be done might depend on the size of your organisation. Obviously, one-to-ones are brilliant for that. But it may be that you will also undertake something like an employee survey to get feedback from larger numbers of employees. It'd be worth thinking about giving employees kind of multiple options to report any issues, including any anonymous feedback that they can provide or a channel for giving anonymous feedback. And also don't forget to engage with line managers to understand the team dynamics and help anticipate any issues before they arise as well. I'm going to hand over to Dan now, who's going to give us a talk about the legal obligations and the duty to protect workers from
Thank
stress.
you, Laura. Next slide, please, Tom. In terms of the legal framework, there's nothing new here. So legal duties stem from the Health and Safety at Work Act 1974, Section 2, which places all employers under a duty to ensure, so far as is reasonably practicable, the health, safety and welfare of all employees at work. How do they do that? Well, of course, Regulation 3 of the Management of Health and Safety at Work Regulations 99 places all employers under a duty to carry out a risk assessment. So that is fundamentally the legislation we are working from here. So there's no change in that regard, but what has changed is the way in which the regulators, namely the HSE, are now using this to say to employers, look, health and safety is not just about protecting against physical risks at work. Stress and mental health is equally important. And if you don't start to think about those risks now in the same way as you do physical risks, then we're not going to hesitate to use our enforcement powers to investigate and, in the right circumstances, prosecute employers for breaching that particular legislation. So you then say to yourself, well, what's the right set of circumstances? Well, HSE say, well, fundamentally three things. Firstly, there needs to be evidence of several employees who are experiencing work-related stress. Secondly, there needs to be evidence of wider organisational failings. So, for instance, a failure to undertake a basic task such as a risk assessment, looking at stress, would be an obvious example. And then finally, concerns regarding stress at work should have been raised with the employer, and they should be given a reasonable opportunity of time to respond and address those concerns. If that's not happened, that would be a bar to investigation. So those are the parameters in which the HSE say, we will investigate and if necessary, we will prosecute if those boxes are ticked. In terms of, next slide, please. In terms of how we comply with these duties, HSE referred to a 5-step approach, and it all stems from the management standards. So firstly, identify the risk factors. Now, as Laura mentioned a short time ago, the HSE have already done that to a large extent. So they have identified 6 areas which are the root cause of stress at work. So as a start point, employers need to familiarise themselves with those areas. Secondly, they then need to look within their own organisation and say, well, which groups of employees are at risk here? HSE say you shouldn't be looking at individuals, it should be groups of individuals, who's at risk, who could be harmed here. And as Laura mentioned, you might be assisted in gathering data beforehand. So looking at turnover amongst a particular group, staff surveys, exit interviews, what are the particular sickness levels. That is all going to help you assess who is at risk. Thirdly, evaluate those risks, look at what those results tell you. Again, refer back to the management standards. Not only do those management standards tell you what the root causes of stress are, they also tell you what is considered to be good practice. Apply that to your own organisation. Are we ticking all of those boxes? If not, would it be a reasonable and proportionate step for us to take in order to satisfy this particular criteria? And then fourthly, record the findings of your risk assessment and your action plan going forward. Of course, that should be your aid memoir to ensure that improvements are made. But secondly, if you are ever questioned, and if the HSE ever come knocking, then of course you can produce your risk assessment and your action plan to demonstrate compliance with the law. And it's worth noting that the management standards, the law doesn't say you have to follow these specific management standards, but what the HSE do say is if you are following these standards, then you will deem to be compliant with the legislation. And then finally, of course, as with all risk assessments, there's a need to monitor and review those going forward. Typically, you should be doing that every 12 months, unless there's a cause to do so earlier. Next slide, please. What are the consequences of failing to comply? Well, very significant. So, as I say, HSE have the powers of investigation and prosecution. If you are ever unfortunate enough to be involved in that, don't expect that investigation to resolve quickly. Typically, investigations will last anywhere between 12 and 24 months. On average, if it goes to court, then potentially it's the same again. So once these investigations start, if they do progress to court, in most sets of circumstances, they don't resolve anytime soon. The other important point to note here is potential individual liability. So yes, employers can be investigated and prosecuted, but so can individual directors and managers within organisations if there is evidence of consent, connivance and neglect on their part. So in other words, the employer, the company, has committed a breach of health and safety legislation, and there's evidence of, for example, a director consenting to that breach. What are the penalties on conviction? For companies, it's an unlimited fine. So in essence, courts will look at the level of culpability, they'll look at the risk of harm or the actual harm caused by the breach, and then they'll also look at the turnover of the employer, and that will provide a start point. Of course, the higher the turnover, the higher the start point, the bigger the fine. So yeah, very significant fines, all introduced by the sentencing guidelines, which have been enforced now for the past 10 years. As regards individuals, of course, they can be fined as well, but they face a potential penalty of up to 2 years imprisonment. So very significant if you are found to have breached the law. And then finally, putting aside sanctions, there's obviously potential adverse PR and reputational damage. If matters do progress to court, this all plays out publicly. The HSE, if they do secure a conviction, inevitably they will publish this on their website, particularly when we are talking about stress and mental health, which is very much a priority of the HSE. So it's something they are looking to publish. They're looking for the right case to prosecute, in my view. And if you are prosecuted, bearing in mind that the success rate is somewhere in the region of 94–95%, statistically, there's a good chance that an employer will be convicted. So that's all, those are all things that we need to bear in mind. Next slide, please. And then I think I'm handing over to you, Matt.
Thanks, Dan. So Dan has been talking about obviously the legal obligations in terms of health and safety points, and turning now to look at some of the employment law obligations, and so the sorts of things are going to be considered by an employment tribunal, and specifically focusing in on the duty to make reasonable adjustments, which I'm sure you'll all be very familiar with that concept. So employers under the Equality Act are all under duty to make reasonable adjustments where either a job applicant, employee, or even a worker is placed at a disadvantage by a PCP. So that's provision, criteria, or practice. So essentially that's some sort of rule in the workplace or a policy or an informal way of doing things that puts a disabled person at a disadvantage in comparison to a non-disabled person. Or they're disadvantaged by a physical feature of the workplace as well. So the question then becomes, of course, whether a mental health condition can be a disability, and broadly, yes, it can. And then specifically for individuals that organisations need to work out whether for that particular individual's condition, whether that classifies as a disability under the definition in the Equality Act. So just as a brief reminder, the definition in the Act is that there needs to be a physical and mental impairment. So clearly here we're looking at mental impairments, and it's got to be to have an effect that's substantial and long term as well. So that in terms of substantial, it means it's got to be more than minor or trivial, the guidance says. And in terms of long term, it's got to last for 12 months or be expected to last for 12 months. And that's got to have that effect on the person's day-to-day activities. And that effect doesn't have to be constant. So, appreciate with mental health conditions that people's symptoms might vary from day to day or month to month, but really looking at the overall time frame there. Another, I suppose, slight quirk to be aware of in terms of considering that question of whether the mental condition, health condition satisfies the definition, is that you have to sort of hypothetically take away treatment that someone might be receiving. So if someone is sort of doing quite well on a day-to-day basis because they're having therapy or perhaps taking medication or a combination of the two, then we need to sort of hypothetically discount that and think, but for that treatment, would the person's condition satisfy the definition? So I think in terms of particular conditions that people suffer in relation to their mental health and whether they can fall within this definition, I think it can be quite helpful to maybe look at the spectrum of conditions. Obviously not coming from a medical background at all, but broadly speaking, we know that there are the very, very serious conditions that people are aware of: bipolar disorder, PTSD, clinical depression. If someone has experienced those conditions over a sustained period of time, they're going to classify as a disabled individual under the Act. Whereas if you look at the other end of the spectrum, is someone who maybe has had a first performance conversation with their manager and they go off sick with stress at work on a doctor's note, which I know lots of us will have seen examples of. The case law suggests that when you apply that to the definition is very unlikely to be a disability in that first instance. But of course, a lot of the examples that employers see are those ones that sort of sit in the middle with stress, anxiety, depressed mood, trouble sleeping, all these things. And really the issue there is working out for that individual with the assistance, obviously, of medical input and guidance, legal opinion as well in some cases, whether that individual will be deemed to have a disability or not. And if so, obviously that does trigger the duty to make adjustments. So if we could move on to the next slide, please, Tom, in terms of complying with that duty. So there's obviously various ways in which an employer can comply with duty to make adjustments, and it will very much depend on the specific circumstances. So we've got a few suggestions here that you might want to think about in terms of particular cases that you have either now or in the future. So the first one that we have is thinking about policy changes. So sometimes that could be additional breaks for an individual that sit outside the sort of standard breaks policy, or maybe paid or unpaid leave to attend medical appointments. So some flexibility around that. Or sometimes for individuals who need extended phased returns to work after a period off for mental ill health. For some people, adopting a more flexible work schedule might be helpful in terms of balancing their work and life commitments. So sometimes reduction in working hours or changes to their start or finish times. And I think there just a practical point is just to ensure that whatever is agreed is properly documented and is also reviewed and stuck to as well, rather than just being something that is discussed at a time and then not necessarily followed up by all the managers who are responsible. Then sometimes we need to think about adjusting an employee's roles, responsibilities within their existing job role, but even then going broader than that, there's a tribunal will expect an organisation to think about other roles that might be suitable for them. So we do see some examples of employees who are dismissed from their role and the employer hasn't necessarily fully turned their mind to what else they might be able to do, given their skill set and experience, with some extra training. if there's something else in the organisation that might be better for them in terms of managing their mental health. And might also be times where especially support or equipment is suitable. So thinking that I appreciate that most of those instances will be in relation to physical ill health, but there might be things like partitions between desks or quiet rooms that are suitable for people who have challenges in terms of sensory overload. So thinking broadly around adaptations that can be made. And then also, I suppose some of the training and mentorship schemes, within organisations, they can also be very helpful for individuals that are maybe struggling in terms of their mental health. And there's obviously plenty of guidance that's available on that. In terms of what's actually reasonable, as you know, that's the big question in all of these cases. It will very much depend on the circumstances of each case in terms of the individual employee's needs, medical sort of guidance on that, and particularly thinking about the resources of the particular organisation. A tribunal, will certainly focus in on that. Essentially, the bigger the organisation, the more expectation there is there in terms of making those adjustments for individuals. And then just looking there in terms of benefits that come about from making these adjustments, because we do appreciate, there is a cost to all of this. But the benefits, as Laura mentioned before, there's certainly a moral point there in terms of supporting individuals and their health, but also that translates into better attendance and decreased absences. And obviously, coming out of that, you'd hope that there's then lower turnover and that decreases costs in terms of future recruitment. And obviously, that healthy work culture, hopefully people are then more productive, better performance, and that in the end helps the bottom line as well as helping the individuals as well. We'll turn to the next slides, please, Tom, and then the next one. In terms of if we're not doing all these things as organisations, what are the penalties and the sanctions for this? So it's important to be aware that non-compliance can lead to employment tribunal claims, and we've seen that these are public in public forums, so there's reputational risk there. And the sort of claims that can see arising from breaches or from employers not making adjustments and not supporting individuals fully in terms of the mental health can be constructive dismissal in extreme cases. So where an employee resigns and says that the breach is so serious that it's a fundamental breach of their rights. So there's obviously losses and compensation arising from that. And then also disability discrimination claims as well. Of course, that is only where the mental health condition amounts for a disability. So the employee will have to get past that hurdle in terms of their claim. But if they can, then there's compensation arising from those claims. And that can include injury to feelings awards, where the tribunal will consider the effect of the discrimination on the individual. But I suppose the bottom line is that the discrimination awards are uncapped. So the exposure is clearly very significant there. Other potential avenues that the tribunal can look at in terms of sanctions if they make a finding of discrimination. One's recommendations. This is aimed something that the tribunal would issue that's aimed at reducing the adverse effect of the discrimination on the claimant. And the tribunals can also make a declaration as to the rights of the claimant in terms of the matters that the tribunal is considering. So just a couple of examples that we've seen of cases involving discrimination relating to mental ill health, fairly recent one. So this year there's been a British Airways case where British Airways were unsuccessful in terms of a claim for failure to make reasonable adjustments. So this was an individual who was struggling with stress and depression. She'd asked for a move to be based at another airport in terms of reducing her commuting time, but that was rejected. There were ongoing absences and her employment was subsequently terminated a few months later for capability. And as I say, that she was successful in that claim And an important point there was that her stress and depression was found to be a disability. So you can see, in terms of what I was talking about before, where conditions will and will not fall within the definition, that was an example of where it did do. The second case that we have there, the NHS case. So this is an individual who asked for, following significant periods of sickness absence, she requested some adjustments to her working pattern to accommodate her mental health conditions, which were bipolar disorder and anxiety. Again, as in the British Airways case, these requests were denied. And she was successful in her complaint for failure to make adjustments and got compensation of over £80,000. So you can see that, in terms of the potential exposure from a financial perspective, also reputationally as well, and these have been reported in the media. And also important to note that these are significant organisations in terms of the size of the tribunal. So it has little sympathy, I suppose, or less tolerance in terms of rejections of requests for reasonable adjustments if the tribunal deems that they were in fact reasonable. And then finally, just to highlight that whilst it's perhaps unusual in terms of the claims that individuals bring, failure to make adjustments can also amount to personal injury in certain circumstances. So looking here at psychological injury to a disabled person. And the key point there really is whether that particular harm to that individual was reasonably foreseeable as a result of the work they do. So that very much goes back to what we were looking at before and what Dan was talking about in terms of looking ahead, considering risk, and carrying out those risk assessments and taking preventative steps. And then finally, if we turn, please, Tom, to the practical steps to take in terms of trying to avoid some of these issues. So we obviously, again, very much turns on the circumstances, but we've got some thoughts here on important things that employers can all be looking at. Of course, reviewing and updating company policies is very important. I suppose first of all, making sure there is a policy covering support for mental health, and also that the content's always clear and accessible and easily understood by employees, and considering whether it's, I suppose, flexible enough in terms of dealing with different mental health conditions, because maybe we focus on stress as a very, very important and common one, but of course there can be other conditions. So ensuring that there is that breadth that it's covering. Also, I suppose with policies, ensuring they are always implemented consistently. Again, not just about having a policy in place, but making sure managers know about them and are implementing them consistently across the board. In terms of policies, that's something that if you do need support with that we do a lot of those reviews and drafting of policies with organisations. So do feel free to reach out if there's anything we can support with there. Turning on to wellbeing programs, so that's something that more and more organisations are engaging with now, offering mental health support wellbeing programs. Again, thinking about what might be good for your particular employees, and also how that's communicated to individuals as well, that's clear and known about. Then thinking about what training can be offered to individual employees across the board on mental health, but also particularly to managers as well, so that they know what resources are there and how to spot the early warning signs of mental health challenges, and how to support individuals that are going through those difficulties, and what support to signpost individuals to. Again, something that we get involved with in terms of training managers within our organisations. So happy to have a chat about that if that would help at any point. In terms of external programs, again, we see more and more of those that pop up. So things like Mental Health Awareness Week, Mental Health Day, and other specific things that sort of crop up through the year. So definitely worth engaging with those and making sure that, again, as well as posters and things like that, that organisations actually put some of those things into practice throughout the year, as well as those times where maybe they've got a bit more focus, but keeping going with those through the working year. Flexible working, obviously something that's very much front and centre of many of our minds at the moment with the legislation and employees' expectations around that, and bearing in mind how that can support a lot of individuals that are struggling with burnout and mental health conditions. For some individuals and some organisations, time off in lieu might be appropriate, so something to consider there. Again, the sort of adjustment that tribunals might expect in circumstances where employees have been working particularly long hours. And a final point that we've got on here is the right to disconnect. Now, that's not something that the government is going to be taking forward at the moment. It was suggested by Labour that they would be looking further into that. But nevertheless, it can be a good thing for an organisation to implement in practice, to give people that ability to sort of switch off outside of working hours. So, as I say, those are all the things that, or some of the examples that can help in terms of taking those steps to comply with the duties to make reasonable adjustments for individuals. And we've talked about the benefits both for the individuals and ultimately the organisation as well, that some of these can have, and appreciate you'll have lots of your own ideas around that as well. So I'll hand over to Laura at that point, just to share any questions that might have come through.
Yeah, super. We actually had one question in advance of this session, so I will just answer that now. So one individual asked whether we recommend medical questionnaires to be used prior to offering employment to individuals to tackle some of these issues. It's worth remembering that medical questionnaires can be used in the recruitment process, but the Equality Act governs quite strictly the reasons for which you're entitled to use one of those pre-medical questionnaires. So the Equality Act actually prohibits employers from asking health-related questions before offering employment, except for in a few prescribed scenarios. So that would be where it's necessary to determine whether any reasonable adjustments are needed for the recruitment process itself. Secondly, to assess the applicant's ability to carry out a function intrinsic to the job. So in that sense, thinking about things like if it is a very strenuous job requiring a certain level of fitness, or if it requires a certain level of eyesight, then making sure that someone is able to pass a vision test, for example. You can also ask these questions as a means of monitoring diversity in the range of people who are applying for work. And in a similar vein, you can ask these questions to take positive action regarding disabled individuals in order to kind of increase the particular sort of diversity within your organisation. A new starter fitness check, therefore, might be more appropriate because it avoids those pre-employment health questions that could breach the Equality Act. So any sort of, I suppose the guiding principle here is that any health-related checks or questionnaires, whether they're conducted before or after an offer of employment, have to be really clearly linked to the requirements of the role. Or for example, you might need to ask those questions to understand if someone can benefit from health insurance scheme that you are offering. Also worth remembering that there are data protection concerns because when you are processing medical information from employees, that involves special category data. So there are specific additional requirements you need to think about when it comes to those questions. And you also might need to get consent under the Access to Medical Records Reports Act, rather, if a medical report is requested from an applicant's doctor. There is quite good guidance on this. If you have a look on the Equality and Human Rights Commission website, they have produced a guidance document specifically on pre-employment health questionnaires. So worth having a search for that. We have run out of time now. I think I can see that there is another question in the box. Thank you. You've got your name on there, so we'll be able to follow up after the session with you. But all that remains to say for today is thank you very much for joining us. I really appreciate your time and hope that you've got some practical tips out of that whistle-stop tour of mental health and wellbeing. You will receive a copy of the slides and the recording from today's session within the next few days. Do feel free to share that with any of your HR colleagues or contacts who you think might find that useful as well. And obviously, you've got all our contact details on there should you wish to get in touch with us or have got any questions about today's session. Equally, happy to receive new connections on LinkedIn if you would like to follow any of our content from the employment and the regulatory team here at FRIS. Thank you very much for joining us, and look forward to seeing you again at a future session.